good evening, everybody, and welcome to our first Red Lion Chambers webinar of the year. My name is Michael Goodwin, and I'm a member of the Red Lion Chambers Serious Crime Group and Fraud and Business Crime Group. And we are delighted this evening to see so many of you in attendance. The aim of the webinar tonight is to provide a legal and practical updater on recent developments within disclosure. I'm joined on the panel this evening with two other members of Red Lion Chambers who I'd like to introduce. Aneurin Brewer is a specialist in lengthy, multi-handed and factually complex trials, often involving drug supply, fraud and other criminal conspiracies. Aneurin is currently ranked in the Legal 500 as a leading junior in the field of general crime. I'm also pleased to introduce Anita Clifford, who both defends and prosecutes. Anita has a general crime practice and is developing a financial crime specialism. Anita is ranked by Chambers UK and the Legal 500. And prior to her call in 2017, she practiced as a criminal solicitor and practiced in Australia since 2011. Well, we'll be covering tonight what I hope will be interesting and relevant topics for the general crime practitioner. And following a general legal updater from me, Aneurin will be speaking on disclosure of electronic material in rape and domestic violence cases. And then Anita will be speaking on the new Attorney General guidelines on disclosure and revised CPIA Code of Practice 1 year on. Before starting, can I just raise three short housekeeping matters? I've been asked to point out that the webinar this evening is being recorded, but your details will remain completely confidential. Secondly, the recording will be available afterwards on our website later in the week if you're unable to remain for the whole thing. And thirdly, due to the format of the webinar and timings this evening, there will unfortunately be no Q&A session at the end. Well, turning then to a general legal updater in relation to disclosure, I want to start really with an introduction of some recent disclosure headlines and developments of interest, and together review, reflect and refresh, to borrow the recent National Disclosure Improvement Plan's published themes. And I'm going to cover in the next 20 minutes or so three particular topics. The first will be the current disclosure narrative that is taking place to provide a context for this webinar. And secondly, to go on and look in particular at two authorities which are of practical application to the crime practitioner and important additions really to any trial lawyer's armoury. So turning first, please, to the current disclosure narrative. Many of us here tonight who navigate the disclosure law and practice on a daily basis will be all too familiar with the current narrative around disclosure. And I think we can probably all agree that disclosure is a topic which impacts on just about every criminal case. It's always in the legal news, and too frequently, and particularly recently, it is regularly reported in the wider media. If carried out in accordance with the prosecution's duties and disclosure, duties and obligations, the disclosure process will contribute to the success of any case. But when failings take place, then evidence can be ruled inadmissible, abuse of process can be raised successfully, and a case can be terminated prematurely. And one recent example of that, where things went very wrong, was in October of last year. You, I'm sure, saw the headlines. The case was a prosecution where Lewis Bloor, one of the Only Way is Essex Towie stars, was a defendant. and he and others were acquitted of an alleged £3 million conspiracy to defraud involving a diamond investment scam. Well, the trial collapsed at Southwark, and in that case, the Crown Prosecution Service admitted that it had failed to disclose material of its commercial relationship with its expert witnesses. It was conceded in the case that the experts had not been instructed in a way consistent with the criminal procedure rules. So what had happened was as follows: the instructed expert witnesses had been employed by well-known auctioneers and valuers. And that organisation had a contract with Metropolitan Police to auction jewellery and watches seized in raids that featured in prosecution cases. The problem disclosed when it was far too late was that the organisation was awaiting the outcome of their tender for their contract to be renewed, and the prosecution did not disclose the offer of a conditional fee agreement by the experts to the police, who were paying their fees. Well, as if that wasn't bad enough, in the same week, the £34 million money laundering trial collapsed at Snaresbrook Crown Court in Essex. And in that case, the judge said there'd been a systemic and catastrophic disclosure failure by the Crown Prosecution Service. And so it's cases such as these which have fueled headlines, sending shudders through the criminal justice system. Headlines such as that by the Justice Group last November, who reported that twice as many cases collapsed in the previous year because of disclosure problems compared to 5 years ago. And indeed, The Guardian has published figures from its own researchers that some 1,648 cases had collapsed over disclosure failures in the previous 12 months to October 21. That compared with what was still a significant figure of 916 cases in 2017. But clearly there's been a very large increase in such cases in recent times. Well, the narrative in terms of disclosure, I'm pleased to say, hasn't all been bad. And there's been a great deal of reflecting that's been going on by policymakers, the government, and prosecution agencies. And many of us here tonight will be aware of what is a considerable drive to change and improve the disclosure process across the board, from the largest and most complex cases to the minor cases heard in the lower courts. And I just want to refer to two examples of this to balance the narrative out. Well, firstly, there's the new arrival on the disclosure landscape of the revised Attorney General guidelines on disclosure, updating what was the original 2013 version. And Anita is going to focus on these guidelines in more detail shortly. For now, I just mentioned this by way of introduction, that the guidelines set out to create a wholly new culture of change to disclosure, having been brought in at the end of December 2020. The second point I wanted to refer to and bring to your attention was in July of last year, when the National Disclosure Improvement Plan Phase 3 was published. And this focused very much on volume investigations and prosecutions. The report included, amongst its key areas, the significance of delivering continued improvement within the disclosure context. And continuous improvement was said to refer to the drive to roll out nationally that which is said to be working well locally. Well, of course, we are all interested and await to see the reported outcomes and results of the National Disclosure Improvement Plan. But the intentions are clear. And so, wrapping up the narrative on disclosure, there is no doubt that it can only be by continuing to properly resource and to improve, constantly adapting to the modern requirements of the changes facing investigators, that things will improve in the disclosure arena. and many of us here tonight are committed to implementing and ensuring that these new developments do just that. Well, turning to my second topic, what I want to do now really is focus on the common law, because the common law continues to contribute to this drive to improve disclosure compliance and practice on the ground. And the case of the Queen and Wren 2021 EWCA Crim 413 is a useful and important authority. In this recent case that was decided last March, the Court of Appeal relied on the development of the common law and the CPIA to stress the importance of retaining material that may affect a witness's credibility and reliability. In that case, the court quashed 14 convictions of trade unionists who'd picketed during the National Builders Workers' Strike in 1972, and were all variously convicted of offences including conspiracy to intimidate, affray, and unlawful assembling. Now, this case had turned on what was essentially identification evidence and the accuracy and credibility of that eyewitness evidence. The case against all the appellants was based on identifications using photographs which had been shown to the witnesses some days after the incident had occurred. And in their statements, there had been descriptions provided by witnesses before they'd been shown any photographs. So what went wrong? Well, an unknown number of original witness statements had subsequently been amended by the police and prosecution before the trial took place. The originals of many of those witness statements had then been destroyed. And as a result, that hadn't been disclosed at the trial, and the existence of those original statements obviously didn't exist. Furthermore, at the trial, the prosecution had assured both the appellants and the original trial judge that they had access to all relevant witness statements. Well, the court found that there'd been significant changes to the witness statements as a result of what was contained in the statements that existed at the trial. The court also found that proof of previous inconsistent statements given by witnesses had been impossible at the trial. And the comparing and contrasting of various accounts of eyewitnesses and how this may have impacted on their credibility and reliability could not have taken place at the trial. And so, perhaps not surprisingly, the Court of Appeal held that the failures of disclosure at the trial had resulted in the convictions being unsafe. Well, importantly, the court had traced the progression of the common law and the influence of the CPIA in its judgment. And the Court of Appeal had stressed the particular significance of material that may affect a witness's reliability and cast doubt on their reliability as being disclosable material that must be disclosed, and that the duty of retention must be strengthened accordingly. And although this case relates to events that happened long ago, the principles remain good and applicable in just about every criminal prosecution. But the icing on the cake can be found in the postscript, which was important and delivered by the Vice President, Lord Justice Fulford. He, in referring to the retention and deletion of evidence, made reference to the digital files, which are now the norm in the modern criminal justice system. He referred to this case as having provided a clear example of why injustice might result when a routine date is set for the deletion and destruction of papers which founded criminal proceedings. Given that most, if not all, of the material in criminal cases is now of a digital format, with the ability to store that evidence in compressed format, Lord Justice Fulford had this to say: "We suggest that there should be consideration as to whether the present regime for retaining and deleting digital files was appropriate, given the absence of relevant court records could make the court's task markedly difficult when assessing the safety of a historical conviction." Now, we, of course, all have obligations to keep documents for a period of time as practitioners under GDPR and data protection. But how long the records kept by courts in digital format following this guidance and indication from the court remains to be seen. But one thing is for sure, that in relation to historical appeals, to ensure the safety of such convictions, the deletion of these documents should not take place before a very long period of time. Well, the final topic I want to cover, and I can only cover it briefly in the time available to me, is the case of Hamilton and the Post Office Limited 2021 EWCA Crim 577. Indeed, no recent update about the law of disclosure would be complete without reference to this case. The case occurred within the context of private prosecutions brought by the Post Office. And in this case, the Court of Appeal allowed 39 appeals against conviction, having rigorously analysed the failures of disclosure in the prosecutions of Post Office employees for dishonesty-related offences. This appeal and its related prosecutions had a national impact and could not have been more significant. The convictions had depended on evidence from the computerised accounting system used in branch post offices, and employees had been prosecuted and convicted on the basis that the accounting system, known as Horizon, was reliable, when in fact it was not. And to make matters worse, the Post Office had known at the time that there were serious issues with Horizon's reliability. The Post Office, of course, as a prosecution authority, in bringing a private prosecution, had a duty to investigate all reasonable lines of inquiry and to consider disclosure and anything which might meet the test of disclosure. It had not adequately considered or made relevant disclosure the problems with Horizon in any of the cases brought before the courts over a 10-year period from 2003 to 2013. The failures of investigation, as well as the disclosure failures, went to the heart of the case. And in every case, the basis of each prosecution had been that the money that went missing in the post offices must have been as a result of theft, cover-up, or false accounting. And so this case showed the crucial link between serious failures of disclosure on the one hand and the court's jurisdiction concerning abuse of process on the other. Following the pervasive failures of both disclosure and investigations, and the Post Office's deliberately misleading and widespread technological flaws which weren't reported, the Court of Appeal held that there was an abuse of process, not only in the Category 1 sense, the impossibility of a fair trial, but also in the Category 2 sense, the affront to public conscience or the unconscionability of bringing a prosecution. Unusually, in the demanding realm of abuse of process, the failures of disclosure were held to be so severe that they tainted the very system of criminal courts. And so perhaps it's no wonder that this case has been described as one of the most shocking cases for some time, and that the serious disclosure failures were, not surprisingly, summarised by Lord Justice Holroyd, paragraph 91, as emanating from a genuine desire by the Post Office not to comply for reasons of cost, and perhaps even worse, the disclosure officer who clearly did not remotely understand the obligations of their role. Well, that's only obviously a snapshot of the case, and it's really no substitute from reading the whole thing, which is, I suggest, a very fascinating case, and an important case, not just for disclosure, but also for abuse of process. And in my view, Hamilton represents an affirmation of proper disclosure as being a mark of a system that strives to realize the rule of law, and one which recognizes the power of both state and private prosecution authorities to ensure the integrity of the criminal justice process. Well, that is all I have time for in my slot. And in a moment, I'm going to hand over to the second presentation this evening. But just before doing that, it's only right, please, and I'd like to thank and acknowledge the considerable assistance that I've been provided with this evening in preparing this short talk by Alex Ben in my chambers, and I'm very grateful to him. So we move then to the second of tonight's talks, and this will be presented by Aneurin Brewer. Aneurin will be providing an insightful drive around the disclosure of electronic material in rape and domestic violence cases.
Thank you very much, Michael. Good afternoon, everyone. When I was asked to give a lecture on disclosure, you can imagine I naturally jumped at the opportunity. There is a huge wealth of guides and manuals, reviews, codes, which have been made available. And I've tried in this slide, which will be available after this event as a handout, to hyperlink to most of those. And if you want to go Pokemon on it and collect them all, you're very welcome to. But the reality is that the vast majority of the material which has been produced over the last few years is often an exercise in platitudes. It doesn't give the sort of practical guidance on the actual problems that arise in common practice. And so I thought it would be helpful to focus on one of the most contentious practical problems which arises certainly in my practice, and that's the status of complainants' digital data in cases concerning defendants who are known to them. So harassment, stalking, domestic violence, and of course, in the most serious instances, rape. And those sort of cases give rise to four principal questions. First of all, when are the police or the investigative authorities obliged to examine the phones of complainants? Secondly, what obligations, if any, do complainants have to provide them when requested? Third, how are investigative authorities and prosecutors meant to approach the difficulty of considering large data sets like forensic downloads of handsets from complainants? And then finally, perhaps most importantly, what options and remedies are available for defense teams in order to try and get this sort of material into their hands so that it can be considered from a defense perspective? And throughout this short talk, I've provided in the slides that will follow some fairly lengthy extracts from the authorities and the guides set out on the previous slide. I'm not going to propose to read them out for any number of reasons, not least the limitations of time. But those slides, as I say, will be available afterwards, and I hope as a handout will be useful as a reference tool in the future for those who've been kind enough to attend. So the first question is, when are the police obliged to examine the devices of complainants? And the simple answer, the platitude that one inevitably encounters in these cases, is when it's a reasonable line of inquiry. And that, of course, goes right back to the Code of Practice, that investigating authorities are required to pursue all reasonable lines of inquiry. But what does that mean in the context of these sort of cases, domestic cases, if I can call them that? And the recent case of Beta James has provided some fairly helpful analysis of how these principles can be applied in a more practical sense to these sort of cases. The first simple answer is they are only obliged to examine a device or seek to download it or seize it where it would be a genuine, reasonable line of inquiry. There's no general presumption in these sort of cases that a complainant's devices ought to be seized and examined. And as you can see in the passage that's been provided on this slide, the test is whether there is a properly identifiable foundation for an inquiry into a particular electronic device. And that, of course, will be fact specific, which again is a little bit of a platitude. But in these cases and guides, there is some analysis of what sort of cases it would not be a reasonable line of inquiry to examine a complainant's phone. Cases of opportunistic attacks by strangers, obviously, presumably when ID is only an issue, historic cases which predate modern civilization where everyone has a phone on them at all times, and cases concerning victims who are so young that they can't reasonably be expected to have an electronic device. The CPS guide has also got some useful guidance on these questions and urges prosecutors and police to consider asking the parties, both the complainant and the defense and defendant, whether or not there might be relevant material for them to examine. Now, exactly how that's meant to work in practice perhaps is a matter for another lecture, but it certainly is incumbent on the prosecution to consider involving both sides. There is, of course, a continuing duty to investigate throughout the course of the case. We often hear the platitude that there's a continuing duty to disclose, but it's important to emphasize there's a continuing duty to investigate. And that means that investigative authorities need to continue to consider whether or not material needs to be seized, i.e. phones, or material which has been seized needs to be examined in new and different ways as the case develops, and in particular, as the defense case develops through the defense statement and other documents in the course of the preparation of the case. And it may well be that examination becomes reasonable as a result of disclosure by the defense. And that's something important to bear in mind in the context of these cases. That said, what examination is conducted must be only that which is necessary to pursue the particular reasonable line of inquiry. And in Beta James, the Court of Appeal emphasized that so far as is possible, inquiries into complainants' phones needs to be limited by, so far as possible, the parameters of time or other considerations to those matters which will actually resolve the reasonable lines of inquiry which arise in the facts of a particular case. It's also important that the lines of inquiry are limited to that which is necessary and the minimum necessary in order to address the questions that give rise to the reasonable lines of inquiry. And in that regard, the court drew the profession's attention to the different levels of extraction which are possible with mobile telephones. And in simple terms, level one is the sort of straightforward, if I can put it like that, downloading of a phone by a detective constable using a standard kiosk or unit at a police station, which generates the sort of reports that we are all very familiar with. And then level two and level three involve more specialist examination that might turn up just material that's been deleted or material which has been not readily available to a straightforward download of the handset. And the helpful guide to reasonable lines of inquiry gives some examples of when those iterative levels of examination might be appropriate. And those examples of deeper levels of examination, level 2 and level 3, include cases in which the offence is committed through the medium of a digital or electronic communication. So, for example, grooming offences, and also helpfully for the defence, where the credibility of the complainant is put in issue from the outset of the investigation. And of course, that will often be the case in these sort of cases where the defendant and the complainant are known to each other. So that is quite a helpful piece of advice from a defense perspective. So the second question then is, once the police or the prosecution have conceded that it is a reasonable line of inquiry to examine at least part of somebody's phone, what obligations, if any, are on the complainant to provide the phone for such an examination? And it's important to emphasize that there is no general obligation on giving evidence or becoming a complainant in a case to allow your phone to be examined. And the authorities make plain that there is a difficult balancing exercise to be had between the rights to privacy and confidentiality that a complainant has and of course the rights of a defendant to a fair trial. And again, I'm afraid we do descend into platitudes a little bit at this point in the guidance. In the recent case of Beta James, there was some helpful advice to the police and prosecuting authorities on various common sense, you may think, steps that can be taken to reassure complainants so that they will voluntarily provide their devices to be downloaded. And I provide here a list of some of the common sense advice that's been provided. But of course, that doesn't provide much assistance to the more difficult cases where, despite the best persuasion of the OIC, the complainant has nevertheless refused to allow his or her device to be examined. And so ultimately, what remedy is available if you have a truly recalcitrant complainant? And the simple answer is, of course, it's always open to the prosecution to witness summons a complainant, as with any potential witness, in order for them to provide documentary or other evidence that is they're believed to have. The difficulty is, in Beta James, the Crown made it clear in this extract that they would only do so, in their view, in exceptional cases. And so that provides very little reassurance to the defense where one has a truly recalcitrant complainant. I've set out in the bottom of this slide the tests which need to be applied in those exceptional cases where the prosecution seeks a witness summons. And of course, not only did the applying authority need to show that it's likely that that person would have material which is relevant to the case, but that the person who is the subject of that application for a summons, i.e. the complainant, has the right to object and can object not only on the basis that they have material which is likely to be material, but that they can also object on the basis that the balance of their rights to confidentiality and privacy outweigh the reasons for issuing the summons. And so, again, we return to the tricky issue of where that balance is to be struck. Ultimately, in Beta James, the Court of Appeal essentially said the remedy is likely to be cross-examination of the complainant by the defense and comment on their refusal or failure to provide this evidence. And ultimately, that might be right, but of course it provides only limited protection to a defendant when a complainant perhaps can give good reasons why she doesn't want her privacy invaded, and thereby avoids potentially exonerating evidence being put in the hands of the defense. Third question is, how should the prosecution and disclosure officers approach the material that they do derive if they are able to, by hook or by crook, get hold of the complainant's digital footprint? And the simple answer, I'm afraid, is that the prosecution are reminded and urged not to simply hand over the download to the defense for them to examine it and see if there's any material which might be of assistance to the defense. While that, of course, is right and consistent with all of the statute and guidance, the problem is, as so many of us who practice in the criminal courts know, the reality is that often it is only when that material is handed over in large part that the defense are able to examine it properly and disclosure failures are revealed. And in most of the cases where disclosure failures have been found, notorious cases such as the case of Allen a few years ago, it was precisely because the forensic download was handed to the defense and the failures of the police to find exonerating material were revealed in that way. And of course, this system places a great deal of trust and emphasis on an overstretched police force who may well cut corners even with the best intentions and miss potentially exonerating material on the handsets of complainants. The police, of course, are not required, forgive me, to read every single byte of the download. That's not realistic in the modern world. And there is ample guidance in the various documents that I referred to at the start of this talk that searches using various parameters or search terms is entirely appropriate. But of course, the prosecution are required to be transparent and to provide those to the defense most realistically through the disclosure management document which is becoming now far more common, particularly as a result of the recently renewed Attorney General's guidance. The important part from this practice note is to recognize that the prosecution and disclosure officers are urged to involve the defense and the court in making the decisions about the methodology for searching the digital device. That could be by the provision of search terms, the identification of particular third parties with whom communications may be of relevance to the case, or other parameters that may assist in finding potentially relevant material. That said, the court has made clear that it's important to only pursue reasonable lines of inquiry. And so those parameters need to be carefully considered by the prosecutor and the disclosure officer so that they are genuinely relevant to the reasonable lines of inquiry which have been identified by the police. And finally, and perhaps to reiterate the point at the start of this section of the speech, only disclosable material should be disclosed. So if disclosable material is found in that data set, that and that alone should be provided to the defense, and other material should either be excluded or redacted so that the focus is exclusively on that material which has been found to be relevant to the issues in the case. The old-fashioned approach of giving the keys to the warehouse for the defense to inspect, sadly, perhaps no longer relevant. So final question is, what remedies, if any, or options do the defense have to try and get their grubby little hands on this material if they can? And the simple answer is that proactive engagement from an early stage, even pre-charge, is realistically probably the best strategy from a defense perspective. And we've already seen references in the slides to a number of authorities and guides that emphasize the importance of the disclosure officer engaging with the defense and indeed all the parties at as early a stage as possible, indeed pre-charge, to see what reasonable lines of inquiry might arise. Once the matter gets to court, the old-fashioned approach that disclosure is ultimately a matter between the prosecution and the defense, and that the judge will only become involved when a Section 8 application is made, is also not consistent with the judicial protocols, and which emphasize that proactive management of the disclosure exercise by a judge at every stage in the case is important. And so it's important that the defense, if they're concerned that material is not being sought or not being examined properly or not being provided when it's disclosable, engage with the judge at an earlier stage as possible. Finally, the ultimate remedy, of course, available to the defense is to seek a stay for an abusive process. But the reality is that that is going to be very rarely an applicable remedy for the defense. The cases make plain that even where there is serious failures by the prosecution, that abusive process is not a disciplinary sanction. And the ultimate question that the court has to ask is whether a fair trial is still possible, despite the failure to seize or despite the failure to disclose the material which has been seized. And the cases again make very clear that it is an exceptional remedy which will be reserved for exceptional cases. The test, it seems, is whether or not there is sufficient credible evidence, apart from the missing evidence, that, if believed, would justify a safe conviction if the trial would proceed, which of course puts the defense in a very difficult position. There may well be sufficient credible evidence in the absence of exonerating material, but that is the approach that the court took in the case of Ibrahim. The test for the defense is to show, and the burden, it would seem, is on them, in as much as there is a burden in abuse process applications, to show that the material which is missing means that they will suffer such serious prejudice that no fair trial can be held. And of course, that places perhaps an unrealistically high burden on the defense to show that material that they've never seen and never had access to would have been of sufficient significance that they can no longer have a fair trial. Finally, the court have made clear that the trial process, much as where in Beta James, the court emphasized the importance of cross-examination of a witness who refused to provide her phone, but the trial process is ultimately usually able to remedy or mitigate sufficiently any unfairness caused by a failure of disclosure or investigation. And the court has also emphasized in Ibrahim the importance of directions from the judge to the jury as to how they should approach such failures. And ultimately, it would seem, except in the most egregious cases, it's likely that a failure to seize this material or to properly consider it or disclose it is very unlikely to amount to an abusive process. And so the best approach, I'm afraid, the defense is to engage early, use the judicial authority as much as possible to ensure that what material there is seized and considered properly. I hope that's of some practical assistance and moves a little beyond the platitudes of the guides. And I now hand over to Anita Clifford for the final section of this webinar.
Thank you very much, Aneurin, and thank you for what was a useful steer through the guidance and principles that you've referred to, which are practical application, obviously, in offences of rape and domestic violence, but also of general application to many other cases. And Aneurin's slides will be sent out to everyone who's attended this evening and available on our website, along with the handout from tonight's webinar after the evening has finished. Well, moving on finally to Anita, and at the heart of the disclosure process, of course, is the Attorney General's guidelines and the CPIA Code of Practice. And Anita is going to walk us through these important documents and these important principles that arise from them, looking at it from a year on from the implementation of the guidance.
Thank you, Michael. So I suppose us all being in the depths and darkness of January means another thing, not just that we're all waiting out for some summer holidays, but we're also 12 months on from, as Michael's mentioned, the new disclosure guidelines that have come into force, coupled with the revised CPIA Code of Practice. They entered into force on the 31st of December of 2020. In this last session, I will be talking about firstly the origins and then some of the real practical implications of the changes before moving to grappling with, I suppose, what is the bigger question and of the most relevance to us is whether any of this is making a difference in practice. Looking first at the origins of the new guidelines, I think as a starting point, it can be said that these documents are well intended. Yes, there is an element of platitude in them, but they come from a foundation of being very much evidence-based. In November of 2018, we had the Attorney General's Office publish a detailed review of the effectiveness of disclosure in the criminal justice system. That, unsurprisingly, cited a raft of problems and it made a number of recommendations. The overall message arising from that review really was that there was nothing wrong at all with our building blocks, the law that governs the disclosure test, but the difficulties really were the day-to-day practice. One of the main issues that were identified were prosecutors being a little too partial to narrow interpretations of the disclosure test. That, of course, contributing to disclosure deficiencies, some of which we've highlighted tonight, but also, I think most importantly, public distrust in the system. The review also found there was a need for greater flexibility and really suggested, and I've put it out on the slide, there was a need to be less strict, to banish that word from the vocabulary when undertaking the disclosure exercise. And really the message should be, if in doubt, disclose. So that's one finding which arose from the review. Another was that disclosure was all too often considered an inconvenient task, or the word that was used was that it was considered to be an afterthought. This ultimately, at the end of the day, is at odds with the investigative mindset, which really ought to be followed throughout the investigation and also any criminal proceedings. Something that the review also identified as a real issue in practice, and I think all of us, whether we defend or prosecute, would only know too well, and that's the mad flurry that happens often the week of the trial, sometimes the day before or even on the day, when it comes to disclosure, and that only disadvantages those that the criminal justice system is sets out to serve, the defendant and the complainant. Now, Aneurin has already touched on this, but there is also the sheer quantity of material that quite often investigators and prosecutors are now expected to wade through, the sheer quantity of digital material. And the review in 2018 very much touched on the need to streamline the disclosure process so as not to overwhelm those who are at the coalface. What followed then, following that review, really was 5 months of consultation about how to respond to these problems. We had consultation with a broad range of stakeholders, and the revisions that entered into force in December of 2020 really are the product of that consult, and it also feeds into work that was already underway as part of the National Disclosure Improvement Plan, which Michael has already mentioned. I think looking holistically at the guidelines and also the revised code, when one compares it to what the old guidelines and the old code did, there are some things which actually have not changed at all. And I think I want to start with just dealing with really what's not different. First, what is clear is that the new documents don't in any way elevate the status of the guidelines or the code. It very much remains guidance only, the purpose being to outline what the principles are, and at least in relation to the code, the expectations that are placed on the police. As was the case previously, the two are designed to complement each other. I think it also can be said that the fundamental principles of the disclosure regime do remain untouched. At the end of the day, the purpose is to ensure a fair trial. The process of disclosure is ongoing. It should be approached with objectivity. Timely disclosure is essential, and the defence have a duty to engage. All those concepts we would only be too familiar with, and they very much remain in these new documents. But parking, at least at this time, as to what is not different, it's also right to recognise that these new guidelines are more comprehensive. They also have been substantially rearranged when one looks at the two side by side. What we have now is by no means an overhaul in any way, but there is a greater emphasis of those principles, and there is clearly an effort to explain how they ought to apply, right from the start of the prosecution and through its various stages. As a sign, the 2013 document was 27 pages. These new guidelines are 39. When one looks in particular at the old guidelines, what struck me is how they were very much focused on the different functions of each separate stakeholder in the disclosure process. For example, the different responsibilities that a prosecutor has as opposed to an investigator or the advocate who's at trial. But this rigid allocation of function really doesn't appear in these revised guidelines. Instead, the focus is on the applicable principles that apply broadly to all involved in the disclosure process, regardless of the hat that is worn. Now, chief amongst these principles is the need for investigators and prosecutors to balance the right to a fair trial against the right to family and private life. This principle is given a far higher status in the new guidelines compared to the old. Also different to the old, these new guidelines do contain examples of how the disclosure regime should be applied in particular cases, and far more detail on what should be done to ensure that a prosecutor is aware of any material that's capable of meeting the test and is actually disclosed, and how early disclosure can be facilitated. As an example of this, and I will touch on this towards the end of the talk, there is an expectation which is expressly put into the guidelines that where there's a defendant is anticipated of pleading not guilty, initial disclosure should be served prior to the PTPH. So we see an emphasis of front loading. Overall, more practical guidance sets out to address the key problem that was identified in the review in 2018. The principles are sound, but the issue really is how they are applied day to day. All of this is designed to quicken the disclosure process and bring about consistency. Whether or not something is disclosed should not depend on the sensibility of the individuals or the prosecutors involved. Now, as for the key changes, there are 4. They start with presumptive categories, more disclosure management documents or DMDs, far greater emphasis of pre-charge engagement, and also front-loaded disclosure. Starting with the first of presumptive categories, in my view, that is really the most radical of the changes that we see in this new document. It is what it says on the tin, new presumptive categories, which applies to certain types of material, meaning that the presumption is that that material should be disclosed to the defence. Of course, this is not to say that that material will be disclosed, but it is significant that the new guidelines spell out that certain types are likely to meet the test for disclosure. And this, at least in theory, should sidestep the need for many Section 8 applications. From a practical perspective, it certainly is worth bookmarking paragraph 87 of the guidelines, as the following types of material now attract a presumption of disclosure. You have here interview records, not just with suspects, but any witnesses, not just the recordings, which are of course routinely disclosed, but any notes and drafts, all telephone messages and calls relating to the alleged offence or descriptions of the alleged offender, all incident logs relating to the allegation, that also includes the investigation log, police pocketbook or notebook entries with a broad range of people, all CCTV footage or imagery of the incident in action, custody records, and any previous account of a witness or anything which could cast doubt over their credibility. Some of what I have just described is, of course, often routinely disclosed, custody records, for instance, but often, and on both sides of the coin I've seen this, it can be a real battle to obtain all relevant CCTV, further still, pocketbook, notebook entries, or the investigation log. The categories, at least on paper, do smooth the path. One glaring omission, however, from that list, which I've just taken you through, is body-worn footage of the alleged incident. It's not expressly referred to. Quite why this is the case is a mystery, but as you would have seen, the categories do include imagery of the incident in action, and quite often body-worn video will fall into that category. Now, going hand in hand with these new presumptive categories, there is also a little to be said about the revised CPIA code. Specifically, paragraph 5.4 is in new terms. It expressly sets out that police are duty bound to retain several documents, and that includes footage of the incident such as CCTV or other imagery. Dash cam and body worn footage would be included in this. Overall, I think that the presumptive categories do serve as a big advancement. Like any presumption, it is rebuttable, but the guidelines certainly are a nudge that these items should be disclosed. And I think for prosecutors and also investigators, as a starting point, there is then an expectation that they will disclose these items and then go on to apply the disclosure test in what the guidelines set out as a thinking manner. Now, turning to the second of the main changes, and that is the greater use of DMDs or disclosure management documents. As Aneurin has already said, there is an expectation that these will be used in far more Crown Court cases, and indeed all Crown Court cases, which is what the guidelines say. Previously, these were only really used in rape or serious sexual offence cases. At the start of my talk, I highlighted how the disclosure review in 2018 called for the investigative mindset of pursuing all reasonable lines of inquiry to be carried out throughout the entire disclosure process. And greater use of DMDs is billed as one way of doing this. The DMD is a document which sets out the strategy to disclosure. It's prepared by the prosecutor, but importantly for all of us, it should set out the prosecutor's understanding of the defence case, and it should also detail certain things, some of which are often overlooked. These are the lines of inquiry that have been pursued, the extent of examination of digital material, whether that's a phone or a tablet that has been seized. It should set out, well, when is it going to be examined? If it's not going to be examined, well, why not? It should also set out linked investigations. It should set out potential video footage and any third-party material and what is being done or is not going to be done to actually obtain it. The DMD should be approached with a defence case in mind and also with an eye on what could assist, even if that is unknown to the defence. According to the new guidelines, it is a living document. In many cases, at least those that I've been involved in, it's often not treated as such, but one should expect it to be updated and for further iterations to be uploaded as the case progresses. If none have been, then this should be requested. I think also worth keeping in mind, although it's by no means a requirement at all for obvious reasons, but there is scope for DMDs to be used in magistrates and youth court cases. The guidelines in particular suggest that where a case is particularly complex, involves lots of legally privileged material, for instance, or there are linked proceedings, then it at least should be considered. Now, two more changes deserve mention tonight. We've heard a little bit about this next one, and that is pre-charge engagement. Specifically, what is different under this new document is that the revised guidelines entertain the possibility of discussing lines of inquiry and the approach to disclosure with the defence at a very early stage, pre-charge, before there is even a case to answer. Also entertained is the possibility of disclosing what would, if a charge were eventually brought, be considered to be unused material at this very early pre-charge phase. You will find that process set out in Annex B of the new guidelines, and it's a process which can commence once a suspect has had his or her or its pre-charge PACE interview, but hasn't yet been charged. And this emphasis of pre-charge engagement is new. In terms of the mechanics, It can be initiated either by the suspect, by the prosecutor, or the investigator. It can involve giving the suspect the opportunity to comment on proposed further lines of inquiry, ascertaining whether the suspect can identify any other lines of inquiry, obtaining consent to access medical or other records, the suspect providing details of potential witnesses at that early stage. Certainly, if a client does take advantage of this pre-charge engagement process, a full record of what went on, what was disclosed, what was communicated, what undertakings were given, is going to be absolutely vital from a defence perspective. The process is uncharted territory. But the idea is that if it is done well, it can be a winner. Certainly for the prospective defendant, it can inform a charging decision in such a way, ideally, that they're not charged at all or charged with something far less serious. But even if it does lead to a charge, it is designed to speed up the disclosure process. The idea is that at an early stage, the issues are identified, and then the disclosure process is then made all the easier. The final main change really comes from the front loading of disclosure, and that you'll find express references to this in the new guidelines. For magistrates' court cases, unused schedule and initial disclosure should take place before the first hearing if a not guilty is expected. The same applies in the Crown Court. The carve out is if, of course, the matter is more complex. Admittedly, that will be the case in many financial crime cases, but there is an expectation that there should be attempts to serve before the PTPH, and this spelling out of early disclosure is a notable shift. I think the big question, though, 12 months or so on, is whether any of these changes are having an impact in either the magistrates' courts or the Crown Courts day to day. Starting with that last change I mentioned, front-loaded disclosure and greater emphasis of that, experience certainly suggests that rarely, if ever, in the magistrates' court is that initial disclosure taking place before the first appearance. Not uncommon for the disclosure scheduled to be served in the days leading up to trial, if not the day before. This experience is better, unsurprisingly, in the Crown Courts. As for DMDs, again, I'm yet to see one used in a magistrate's or even a more complex youth proceeding. But in the Crown Courts, they are being used more widely. Occasionally, the DMD, however, might be uploaded far later than what the guidelines envisage. I think they do vary very much in quality. Some are comprehensive, they detail the reasonable lines of inquiry, others are less so. In a recent case, for example, in which I was involved, there had been at least 2 phones seized on the basis of many suspected communications between the defendant and the complainant, but nowhere in the DMD at all was there mention of the phones or even mention of any plan to examine them. And I think this serves as a good reminder to become familiar with what really should form part of the DMD. What is still, I think, not yet making an impact is the pre-charge engagement process. And in due course, it will be interesting to see whether it takes off at all. Certainly in financial crime cases, I can see the utility of it. But for defence practitioners more broadly, funding is likely to be an issue. The guidelines also suggest that the engagement does not have to follow an overly formal process, but still a framework is needed as to when it will be appropriate and how it will work. The presumptive categories, I do get the sense that these are making the most difference. Some prosecutors do still retain a strict approach. They are more in the rebut rather than the presumed camps. but whether prosecuting or defending, the categories often enable disclosure requests to be answered more swiftly, often favourably, without the need to get bogged down in protracted requests or unnecessary applications. They certainly streamline the process for obtaining relevant prior convictions and CCTV, and I think it can only be hoped that we will see more of this. The year, however, has been far from uneventful when it comes to disclosure failings. At the start of tonight's session, Michael already mentioned the Bloor diamond fraud case and the £34 million money laundering case that collapsed in Snaresbrook. That was in October. That was during what was billed as National Disclosure Week, which was some 10 months on from the launch of these new guidelines and the revised code. I think what this shows is that the problems do very much persist despite gallant efforts, certainly on paper, to improve and headway being made in many cases in practice. But away from the headlines, I think that there are overall signs that disclosure is being looked at more carefully, certainly at an earlier stage. It is a long game, but 12 months on, these new documents are a much needed and welcome step forward.
Well, thank you very much indeed, Anita, for that detailed and careful analysis of the guidelines and their practical impact. And of course, these really are of general application in every case now. Well, we've slightly overrun, so apologies for that. But on behalf of all three of us and Red Lion Chambers, I'd just like to thank you all for attending the webinar this evening. And we very much hope that you found the various talks informative and applicable to your day-to-day practices. If you have any questions or in any way we can assist any of you further, please do get in touch with us, either by email or by telephoning the clerks. Just before I sign off, can I just plug our next webinar, which will take place on Tuesday, the 22nd of February, when Simon Spence QC, Joshua Ellis and Francesca Kirby will be featuring in the bill Back to the Future, the past, present and future for abuse of process, which promises to be a very informative and enjoyable webinar. Please register for that and please join us if you can. Also, we invite you to regularly check out our social media presence for other webinars coming up in our program throughout the year, and you'll find those all on our website. That's all we've got time for this evening. Thank you again for joining us, and I wish you all a very pleasant evening.